Welcome to the Innovation Race podcast, where we meet fascinating inventors, innovators, politicians, and leaders who share the view that what's best for our country is to protect patents and keep innovation in America. Now, here's your host, Jenny Beth Martin.
Our team adores Judge Paul Michel. He served on the federal circuit for 22 years. He judged several thousand appeals and authored more than 800 opinions, one-third concerning intellectual property law. He was designated one of the 50 most influential leaders in intellectual property law in the world. He retired from a lifetime appointment to be free to speak out on the need for better patent policy. And we use the term retired very loosely. In reality, Judge Paul Michel started a whole new segment of his career after his retirement, and he's one of the busiest retired people I've ever met. I know you're going to love learning from Judge Paul Michel. Judge Michel, thank you so much for joining us today.
Happy to be here with you.
So, before we get into patents and intellectual property, let's just talk a little bit about you. You're a retired judge, which means you were an attorney. What brought you to where you are today? Tell us a little about you.
Well, I started out in Philadelphia, my home city, as a criminal prosecutor. But later I came to Washington, actually in 1974, and I worked at the Justice Department twice and as a staffer at the U.S. Senate also twice. And then in 1988, President Reagan appointed me to the Court of Appeals for the Federal Circuit. I served there for 22 years. I retired in 2010, even though I didn't have to. There's no age limit because sitting judges, quite properly, are not supposed to be heavily engaged in political or controversial public policy issues. And during my time in the court, it became clear that the patent system was being enfeebled by various so-called reforms, and that trend needed to be reversed. So I retired voluntarily, and I've spent the last 12 years primarily trying to educate policymakers, all kinds of policymakers in Congress, in the media, in think tanks, and elsewhere about how the patent system drives innovation.
Then it is really amazing to the team who worked on the documentary and the fact that you're retired, and instead of just retiring and going and play golf or going to Florida, whatever else people do when they retire, you're championing this cause. You retired so that you could essentially start another segment of your career and champion this cause to try to fix the patent system.
That's true. I guess retired is a misnomer. It's really not the right word. I changed jobs would be a different way to put it. I've done some consulting, but my primary focus since retiring in 2010 has been to try to help revive and rescue the ailing patent system that has been reformed into weakness, which is hurting the country and our technological leadership, our growth, and even our national security. So it's a very important campaign, and I've been working on it 6 days a week for 12 years.
Wow. So what have you seen that has weakened the patent system and enfeebled it? And what things happened that made you so alarmed that you decided you had to shift your careers at such a late stage in life?
Two main things happened. Number one, the Supreme Court began about 16 years ago to issue several decisions which sharply weakened patent rights. And that continued from 2006 through 2014. And at about the same time, the Congress intervened into the patent system structure to create a new forum in the Patent Office called the Patent Trial and Appeal Board. And it was set up with good intentions, but had many unintended and negative consequences, all of which tended to weaken patent rights and make it very easy for companies accused of infringing a patent to get the patent invalidated in the Patent Office, even though they couldn't get that same result in the courts of law.
What is the difference between the PTO and a court of law?
Well, the Congress, in enacting what was called the America Invents Act, it was enacted in 2011 and came into force in full fashion the next year. They designed this new forum in the Patent Office, but instead of using the standards the courts used, they lowered the bar of what you have to prove in order to invalidate someone's patent. And that is why the results in the Patent Office are more hostile to patents than the results are or would be in the courts.
How did they lower the bar? What would you do in a court versus what you would do over in the PTO?
In courts, a patent is strongly presumed to be valid because it was issued by an expert agency, namely the Patent Office. And therefore, a very high burden is erected that must be met by a challenger in order to invalidate the patent. The legal terminology is clear and convincing evidence. The normal standard in commercial litigation is something lower than that lawyers call preponderance of the evidence. So in enacting this new statute, the Congress lowered the required burden of proof from clear and convincing down to a mere preponderance. And that's what made it much easier to invalidate patents. And in addition to that, they let anybody file a challenge. You didn't have to have any interest in the case. You didn't have to be sued. You didn't have to have any logical reason. You could just be a busybody or an ideological opponent of patents, and you could file in the Patent Office one of these challenges.
And in a normal court of law, you have to have standing.
Exactly.
And so when they let anyone do it, there's no burden of standing for the person filing suit.
Correct. There were three big design defects, in my opinion, in the America Invents Act. Number one, they lowered the burden of proof, as we've been discussing. But number two, they omitted any standing requirement, which, as you say, the courts always require to be met in order to maintain a lawsuit. And number three, they weakened the presumption of validity that courts accord to a patent. So in those three ways, they made it much easier for all sorts of people to knock out patents in the Patent Office. And then the Patent Office, as it implemented this new congressional design, made it even worse in various ways that are a little bit complicated to explain, but the weakening continued past when the statute came into force in 2012 and progressively got worse and worse in the years between then and today.
In the weakening of it, one of the things that you just mentioned, so in a court, you would presume that if the Patent Office gave a patent, that it's valid because it's coming from the Patent Office. Well, I think it's important that we see the full phrase of what the Patent Office is. It's actually the United States Patent Office, or Patent and Trademark Office, the USPTO. So it's actually a government agency or department who is granting the patent to someone in the first place. And now the exact same agency that has granted it is turning around and taking it away. Why don't they wouldn't it be a lot faster and a lot less expensive for everyone involved if we're going to have this system, they just say, okay, well, we're going to grant the patent. Let's run over here to see if we can invalidate it first, and then let's just grant it and invalidate it in one fell swoop.
Well, I don't know if that would be
I don't really think that's good, but it
not.
Seems like it'd be a lot faster than what's happening right now.
Yeah, well, the system is inefficient, and it's costly to inventors and those helping them, because first they have to spend money to get the patent, not only paying fees on multiple occasions, but also paying lawyers who are almost always involved in drafting the patent and meeting the demands of the Patent Office officials, called examiners, in order to get the patent issued. So it's an expensive and slow and arduous process to begin with. And then when the patent can be challenged later, any time in its 20-year lifetime, by anybody, for any reason, good or bad, that's a problem, in my opinion. That's not good public policy. So it's created a kind of a nightmare scenario from the standpoint of inventors, investors who back those inventors, the companies that own the patents, and try to enforce their rights because they can be attacked simultaneously in the courts and in the patent office at the same time. So you have more delay, more expense, more risk of invalidation, and huge numbers of patents that looked perfectly proper when they were issued have been invalidated by this new tribunal in the Patent and Trademark Office that's called the Patent Trial and Appeal Board.
And I call it PTO, but it's PTAB. I got that wrong just a second ago. You were a judge. What did you have to do to become a judge? What was the process for you to go from being an attorney to being a judge?
Well, when I was considered to be appointed by President Reagan in the final year of his administration, of course, 1988, actually it was in 1987 that the consideration began, and I was interviewed by many people, including FBI agents. I was told later that the FBI questioned 300 different people, starting with my childhood and then going right up to date to 1988. So there was that. A great many legal groups. The American Bar Association has a committee that vets potential judicial nominees. So I had to submit documents to them, answer questions from them. And there were 5 or 6 other entities that also wanted to make inquiries of me, of what my background was, what my thoughts were about intellectual property and so forth. And then, of course, people in the White House and the Justice Department got involved in the screening. This, again, was in the fall of 1987. And then ultimately, I was recommended to be appointed by President Reagan. And that was greatly assisted by senators on the Judiciary Committee, particularly because I had worked with many of them, both Republicans and Democrats, but mainly Republicans, because I was a staff aide to a Republican senator at the time, Arlen Specter, now deceased, from Pennsylvania. And that helped a great deal to sort of get me through all these different screens and evaluations. And I'll tell you one thing that I found really charming. When I was selected in mid-September of 1987, President Reagan personally called me on the telephone.
Oh, wow.
And I learned later that he took the time and trouble to call every single person he was about to nominate for a federal judgeship at any level. And I thought that was really wonderful. I've never heard of any other president doing that.
That's a very special touch. There was a lot. Interviewing 300 people. It began in 1987. You were finally confirmed by the United States Senate in 1988?
Yes. I was formally nominated in, I guess, late December. I had a hearing in February of 1988. In March, the process was concluded. I was confirmed by the Senate, and the formal appointment papers were then signed, again, by President Reagan. I proudly have them on the wall in my home. So that's sort of how it happened. And the senators had a big role in that. But also, I had amassed something of a record in the Justice Department, where I served 2 long stints. And in addition to spending 7 years as a staffer to Senator Specter, I had also spent several years as a counsel to the original Senate Intelligence Committee in the mid-'70s. So I had a long track record, and a lot was known about me, and it was all available. It's all in some huge file somewhere, I suppose. So they had a lot to go on, and they made the selection, and I was very happy to be chosen. And then I got to serve from 1988 until 2010 when I retired. And in addition to being eager to be free of the restrictions on federal judges getting involved in overtly political matters, which would require me to, of course, retire and surrender my commission in order to have that freedom. I joke with people that I retired in order to return my First Amendment rights and
Right,
make them
right.
usable again. But in addition to that, it was just an appropriate time for a number of other reasons. One was that chief judges are limited by age, and I was about to turn 70, which would mean I would be dethroned as the chief judge and put back
Okay.
in the ranks of the non-chief judges.
Okay.
So that was another factor. But the main impetus was to be able to participate in educating policymakers and other people about the importance and value of the patent system. And so that's what I've been doing ever since.
Okay. And they put you through that process, not all of the background checks and so many people being interviewed and looking at your career history and then you interviewing and talking to yourself with so many different people. And then the Senate confirms you because you're making decisions that affect people's lives. You're making decisions about whether they had the right to do something or not to do something. You may have to take things that one person thinks is theirs and give it to someone else because it actually didn't belong to that person. There's a lot of responsibility that goes with that. What happens for the people who are part of this tribunal on PTAB? Do they go through a similar process?
No, the judges, as they're called, but they aren't really judges. Judges properly considered are Article III judges from our Constitution. They're part of the federal judiciary. The so-called judges at the Patent Trial and Appeal Board are administrative adjudicators that are part of a government bureaucracy, a government agency, as you said earlier, which is what the Patent Office is. They're not confirmed by the Senate. They're not heavily investigated the way federal judges are. I think they've selected people of quality. There's something like 270 of those so-called administrative patent judges now. So they're not unqualified, but they're not vetted with anything approaching the carefulness of federal judges. And I think the careful vetting of judges is very important. Judges have lots of power, just as you said, important powers to make decisions that affect people's lives and their fortunes as well. And it's a challenging job to be fair, to follow the law, to be sure not to show favoritism to one side or the other. And it's a challenging job to do well. So I think you couldn't have too much carefulness in the selection as far as I'm concerned. And it's probably a weak point of the selection of PTAB judges that they aren't put through that kind of external process. They're vetted within the Patent Office, and their appointment is actually signed by the Secretary of Commerce, who's the overall boss of the Patent Office. But it's not comparable to the way federal judges are selected and examined before appointment.
And I'm sure that that many of them are experts or experts in their field. They understand what they're talking about, but they're making decisions that are not just about a patent. Those decisions have such deep consequences, especially if somebody has a patent, they've risked everything, shown it to the entire world, thinking that in exchange for doing that, our government is going to give them the exclusive right to use what they thought of themselves, and they've poured their life savings into it. And it seems like if you're not, the process that you just explained that you had to go through, I think just going through that process adds weight to the responsibility that you have as a judge. Whereas being told you're an expert and selected because you're an expert maybe doesn't, it doesn't add the same kind of weight. Maybe they don't even realize, or maybe they do at this point, the impact that they're having on regular American citizens who have the right to have have exclusive use of their ideas.
It's important, I think, to remember the phrase you use starts in the Constitution. It talks about exclusive rights to their discoveries and inventions in Article 1. And, of course, the article authorizes the Congress to create a statutory patent system, which they did in the very first Congress, and it's been continued ever since throughout the life of our country. And the patent statute enacted by the Congress also seeks to assure that the rights are meaningful. The patent is specifically called out as property in one section of the Patent Act. Another section provides for injunctions to be issued to order infringers to stop infringing immediately. So the statutory provisions that are the framework of patent law in America, I think were well designed by the Congress and represent good policy, certainly the policy that the Congress agreed on. And the courts have kind of dismantled that to a great extent, particularly the Supreme Court, which is a little ironic. The Supreme Court is often thought of as the court that's going to protect and defend the Constitution. But I think in the case of patents, they've really weakened patent rights and to some extent undermined the statute as enacted by the Congress and contemplated and intended by the Congress. And I think that's very unfortunate. Now, what happened essentially was that there were said to be some abuses of patents by certain parties asserting patents that maybe were not valid or not actually being infringed. There was a huge hullabaloo in the period of 2005 to 2011 when the statute was amended by the America Invents Act. And essentially what happened is the ills of the system were greatly exaggerated by parties who were only interested in their own bottom line profits. But they overpowered the Congress with lobbying, and that's why the design defects appear in the America Invents Act. And so you had the Supreme Court on one hand, the Congress on the other hand, the Patent Trial and Appeal Board implementing the new statute on the other hand, and all of these forces coalesced to combine to greatly weaken patent rights and to really put the courts in a secondary position. Now the Patent Trial and Appeal Board is almost more important than the courts. So, for example, even a patent that has been held valid and infringed in the courts of law can be invalidated later by the PTAB.
It seems to me that actually is undermining the courts then. So the PTAB winds up with more power than the courts and judges who went through all of that process being nominated by the executive branch and confirmed by the legislative branch.
Yes, well, even aside from the qualifications and the vetting, think of how anomalous it is that a low-level administrative body in the executive branch can overrule the courts. If we made a chart, we'd put the Supreme Court at the top, and then the Federal Circuit and the other appeals courts just below that, and then the trial courts just below that, and then administrative bodies at the bottom of this four-tier stack. But in practice, the body at the bottom, the PTAB, can overrule the district courts, which I just think is a terrible anomaly and crazy. It turns the hierarchy upside down.
There's a lot going on in our government that turns things upside down. But you're right, that definitely does. No, you talked about some of the things that the Supreme Court got wrong. Can we unpack that a little bit? One of the things that it's my understanding that they messed up is how we deal with injunctions. And I think that when you're talking about injunctive relief, unless you're actually the person who needs injunctive relief, it just sounds like words, and most people don't understand what that is.
Right. Well, an injunction is an order that a court can issue if it has found a patent both valid and actually infringed by the defendant. And it's an order that says, stop infringing right now on pain of contempt of court, If you keep infringing, you can be fined. And if you keep infringing beyond that, you can probably even be jailed. I don't know that that's ever been done, but it's a serious order. It's taken seriously. And what it does is it not only protects the patent owner from ongoing infringement, but it also provides leverage that promotes settlements, which is a very important part of our court system. The courts can't possibly adjudicate more than a small percentage of the total number of infringement cases that are filed every year, which is something on the order of 5,000 or 6,000 cases per year. But the courts can only try a few hundred. There just aren't enough judges to try all the cases. So most cases have to end in a settlement between the parties. And the settlement is driven by the bargaining power of the patent owner versus the bargaining power of the now adjudicated infringer. And the injunction gives a lot of leverage to the patent owner after the patent owner has successfully proven infringement of a valid patent. By taking that away, the leverage is all gone. And so what's happened in recent years is that infringers have deliberately infringed and kept infringing and refused to take a license, even though they knew they were infringing a valid patent, violating a valid patent. And they can get away with it because if injunctions are almost impossible to get, which is the current state of affairs, I would say, then they have every incentive to just drag out the litigation and to hope to invalidate the patent in the PTAB or in the courts, to hope they might never have to pay. Maybe the patent owner will run out of money and have to give up, or at the worst, the infringer might have to pay a modest amount 5 or 10 years after they started infringing. So the lack of injunctions completely inverts the power dynamic between the patent owner and the infringer.
And that, I think, is extremely important because a lot of times the people who are the patent owner are, some of them may be small companies or medium-sized companies, and some of them are the large companies. So anyone can have it. But oftentimes you've got these smaller, brand new inventors or smaller companies who have the patent. And if you've got an infringement happening from a very big company that has enough in their cash reserves, they could eat 10 of the, maybe even a couple hundred of the patent companies in their lunch hour and think nothing of it. That really makes it very lucrative for the big company to just infringe. They can do so knowing that it's just spare change to them.
Right. Some people call that predatory infringement because it's deliberate and malicious. Other people call it efficient infringement, meaning that you make more money if you infringe than if you don't infringe. So the system is having exactly the opposite outcome of what we ought to want to encourage. So it's gotten really quite crazy. The reforms, if we can call them that, were overdone by Congress in the ways I mentioned, overdone by the Supreme Court on injunction, but also on other patent issues. And the combination has really decimated the patent right. And you very correctly point out that there are a very large number of smaller companies, individual inventors, startup companies, universities, hospitals, research institutes, small emerging businesses, and they tend to be very dependent on patents because they don't yet have a big revenue stream. So they're dependent on investment from outside investors like venture capitalists and others. And those investments are usually not made unless they can be protected by patents. And they're not going to be made if the inventive entity has a patent, but it looks really shaky because it's going to be trashed by the Patent Trial and Appeal Board or otherwise invalidated. So the cumulative effect of all these overcorrections is really very pernicious. So the companies that most depend on patents are now in the weakest position, and the huge companies that have vast cash reserves and usually are not very dependent or at all dependent on patents can get away with infringing So we're doing it backwards. The little companies that need the protection aren't getting it, and the big companies that don't need much help are getting all kind of help from the Supreme Court and the Congress, probably unintentionally, but as they say, unintended consequences are a frequent phenomenon in Washington, D.C.
That's exactly right. You said something about how there are maybe 5,000 infringement cases, and the courts can only take on a few hundred each year. I'm sure that knowing that is part of what drove PTAB in the first place. So we're trying to solve a problem, and we can look back on it very cynically, and sometimes I do that with Washington, D.C., and attribute things to it. But if you just want to give Congress a benefit of the doubt, they probably were trying to solve a problem, and they were completely lobbied about all sorts of issues, and they thought they were trying to solve the issues that they were being told about.
No, I agree. I think Congress had good intentions and was acting on information that had some truth and reality to it. They were heavily lobbied. There's no doubt about that. For 6 or 7 years, heavily lobbied. Not only in terms of visits on Capitol Hill to members and staff, but massive campaign contributions, and big companies that didn't like patents hired dozens and dozens of public relations firms, law firms, and lobby firms to plead their cause, and they did it loud and clear every day for 7 years, and they're still doing it even today. And they basically drown out the voices of small business, even though small business is the backbone of the American economy and always has been. There are thousands more smaller companies for every Google or other giant company that you might want to mention. The Federal Circuit's first Chief Judge, Howard Markey, said that in the modern economy, a patent was the same thing that the six gun had been in the days of the Wild West. It was the only way to get justice for the little guy.
Wow.
A lot of truth in that, I would say, still today.
And we've got to make sure that it's still the tool that can be used to get justice. Okay, so we've talked about the problems and the breakdown in the system right now. What do you think these are? Is this causing a threat and a concern to America as a whole? Is it impacting our security as a country?
Sure. There's a famous saying in Washington, I'm sure you've heard it, maybe even used it yourself many times. If you want to understand what's really happening, follow the money. If you look at the investment flows of American money, it presents a frightening picture in recent years. So, for example, if we look at venture capital investments, used to be that 90% of American VC capital was invested in America. Now it's down to 50%, from 90 to 50. Where's it going? China. U.S. venture capital is being spent in China. Why? Because China has a much stronger, more favorable system where injunctions are routine, where patents don't get easily invalidated, where the delays are much shorter, the litigations are much cheaper. So in many ways, their system is now better than ours, even though ours for decades, even centuries, was the gold standard of the world. But we've so degraded our patent system, and China and all of our commercial rivals in Europe and elsewhere in Asia have upgraded their systems. So now we're at a competitive disadvantage, which we've inflicted on ourselves, and it's terrible policy. And not only VC money, but the money of corporations that used to be invented in serious technology is now being spent increasingly in other directions, whether it's buying back stock or raising dividends or expanding the business or building new factories or whatever, all of which are perfectly legitimate purposes. But you need to have enough research and development to keep America ahead of strategic rivals and commercial rivals in hard technology, like computer chips and hundreds of other technologies. We used to be the world leader in virtually everything. We still are in some things, but China is closing the gap really fast. And Europe and certain Asian countries, including Japan and Korea and Taiwan, are also serious competitors to us now technologically. And it's all a result of weakening the patent system. If you think of the contrast between the last decade and the decade of the 90s, it's really startling. In the decade of the 90s, IBM, famous high-tech company, wasn't using some of its patents. It had enormous numbers of patents, good patents, carefully obtained. So they decided to license all the patents they weren't using. And I think there were tens of thousands of those patents. They licensed them all. Everybody who was using the technology willingly paid, voluntarily paid, without controversy, a reasonable licensing fee. So IBM received billions of dollars per year in licensing fees, and they never had to file a single lawsuit in that whole decade.
Wow.
And then you fast forward to the most recent decade, and nobody takes a license anymore. The attitude is, I can probably kill the patent. I can drag this out for years and years and years. I may be able to bankrupt the patent owner before they can get to the end of the litigation warfare that typically lasts 5 to 10 years. And so, we've created chaos unintentionally and kind of unseen, underappreciated, which is part of the reason why I and many, many other people are trying so hard to educate policymakers and media people and economists and politicians, all kinds of people, about the consequences of so badly eroding our patent system. But they're really quite severe. The National Commission on Artificial Intelligence, National Security Commission on Artificial Intelligence was its proper name, pointed out that partly because of the weak patent system, we're losing ground in key technologies like artificial intelligence. And there's a whole list of others: quantum computing, robotics, hypersonic missiles, computer chips, and on and on. And of course, also in the human health area of advanced biotech inventions. And all of these areas of technology are shrinking because their investment base is shrinking. And that's primarily due to the weakening of the patent system. And nobody seems to understand this. The economics, in a way, are very simple. Investors, whether they're company officials or outside investors like venture capitalists, seldom invest unless there's some protection, usually by patents. So if the patents become unreliable, then the investment levels go down. And that's what's actually happened. Now, people say, well, don't worry, because the government funds a lot of R&D, so we'll be fine. No, we won't be fine, because for every dollar the government spends on R&D, private industry has to spend 100 times more of private capital. So if the private capital is being discouraged rather than incentivized to be invested in technology, it's going to go somewhere else. It's going to go abroad, which it is, as I mentioned before, not only to China, but significantly to China. But in addition to that, it's going to migrate out of technology into other types of business activity. So you see a lot of VC money that used to be spent on hard technology like chips now being used to be spent in entertainment.
Right.
And other things that don't depend at all on patents. So the money flows are terrible. They're going overseas on the one hand and out of technology into non-technology on the other hand. This is exactly the opposite of what we should want as a country.
And when it goes to, there's nothing wrong with entertainment being funded. You're not opposing entertainment being funded. But when you don't have the investment going into new and emerging technologies, those new and emerging technologies create brand new markets, and they create new jobs because it's a brand new idea that no one has ever thought of before. There are things that happen on top of that, and sometimes entire markets and industries just from one idea or the innovation on top of that idea. I just think about how much our life has changed since we put our computer in our on the phone and in our pocket, and have the camera and everything else with it, and we can hail rides, and we can pay fares and transfer money and do our banking and so much on this, and that's created all sorts of new jobs and new ideas that we never would have had. So it's not that entertainment is bad. It's that we're preventing the new markets from ever even being able to emerge.
Yeah, I think it's a matter of balance. Of course, it's good to have investment in entertainment, but it's also important to have adequate investment in serious technology. Okay to buy back stock, okay to pay good dividends, even higher dividends. All those are good things. But the question is, do you have them in sensible balance with the money needing to be spent on R&D? We used to have a good balance. I think now we don't have a good balance. And that's a huge problem for the country. And consider this in terms of irony. The companies that are campaigning the hardest to continue, even today, to weaken patents further than they've already been weakened, tend to be the so-called high-tech or big tech companies, mainly based in Silicon Valley, California. But if you look at Apple or Google or the others, they actually started based on patents. That's how those companies got launched. They got the investment because they had patents. And of course, now patents are just viewed as an annoyance. They're not dependent on patents. They don't like being sued, whether they are infringing or not. So they keep trying to weaken patents further. Some people joke that, not a joke, of course, but that it's almost like they want to pull up the ladder behind them after the patent system got them up to a high level, which pretty much seems to me to be what's happening. And as you said earlier, they have so much money, they can spend tens of millions every single year on lobbying. And so now we see ads on buses in Washington, D.C. that say, patents kill. That's a lie. Patents save lives. Right. Patents are behind the vaccines that are fighting COVID.
Right.
So, but it's all propaganda. It's all distorted kind of PR. In a way, it's lies, exaggerations, distortions, omissions, etc. So the entire public debate about patent policy has been corrupted. It's not an honest, fact-based discussion trying to get good compromises, good balance, good policy. It's just kind of PR warfare of who has the most bucks is probably going to win the argument.
So what do you think, how can we help protect and strengthen the patent system?
Well, there are leaders in Congress, particularly in the Senate, who have educated themselves extremely well. It's bipartisan. I'll just take two examples. Senator Tillis, a conservative Republican, Senator Coons, described himself as a centralist Democrat. I guess that's a fair categorization. They've been working hand in hand for years to try to fix one of the three huge problems in patent law, which involves eligibility standards, tests for what's even eligible to be considered for a patent, even if it can meet all the other tests in the patent statute. The Supreme Court not only messed up injunctions, but they messed up eligibility law like crazy in 4 decisions between 2010 and 2014. And ever since, they've been asked more than 50 times to review their case law and fix it. And they've turned down every single one, including this summer they turned down a review of a case called American Axle. So I conclude from that they're not going to fix it. And the Federal Circuit, as a subordinate court, can't fix it. It has to follow what the Supreme Court has said. And the Patent Office also can't fix it because they also are forced to say follow what the courts do. So by default, the only agent of change that really has the necessary power to fix all these problems is the Congress. And Senator Coons and Tillis, and there are others who support them. It's not only those two, but they're two of the key leaders. They not only have a bill to fix the eligibility problem, and I think it's a very good bill. It was introduced just in August after years of work. But they also have, at least Senator Coons has, a bill called the Stronger Patents Act, which would fix the injunction problem and the problems at the PTAB. So between the bills those two bills, all the big problems would get fixed. So then the question is, well, can we get those bills moving forward? Can we get them passed? Can we get them enacted into law? And that's why I and many, many others are working so hard to help Congress get over the propaganda, endless talk about patent trolls, which is just a propaganda pejorative. Right. It's not a meaningful term. And all the other slogans, bad patents, patent abuse, litigation abuse, on and on, all that kind of talk, like patents kill on buses. It's all just polemical propaganda. It's not serious talk. And we need to have serious talk in this country to get a balanced patent system and revive our economy. As you mentioned, whole industries get created by patented technologies, and good paying jobs, not just a lot of jobs and more jobs, but good paying jobs get created. And that means not only does gross domestic product go up, but also that family incomes go up and people are better off. And company profits go up and the company's better off. And government tax receipts go up, and so we can rebuild the roads and do all these other important things that we need to do, which we aren't doing well enough, at least in my opinion. So it's a whole cascade of problems, but if you fix the problems, you get a whole cascade of benefits going forward in terms of economic growth, national security, job creation, and all the rest. So it couldn't be more important, and it's challenging for ordinary voters or policymakers to understand patent law. It's kind of arcane and geeky, and it's full of obscure phrases that are hard to understand. But it can be done. It has been done. There are journalists out there who have a good understanding. There are people in Congress who have a good understanding. I mentioned two, but another leader is Congressman Massey from Kentucky, who himself is an inventor who has several dozen patents. He's another leader. And there are others. Senator Hirono and Senator Cotton have been active in this space, and others. So there's a growing number of well-informed people in Congress. And my hope is that either Congress will fix the problem or it will advance toward fixing the problem so smartly that the courts will finally wake up and figure they better fix the problem themselves. I don't really care in the end which part of our government fixes the problem, but we need to fix it. We need to fix it really fast because China is closing in faster than you can count.
You understand. I'm just so impressed with you. You're 81 years old, and you understand the law, of course, because you were an attorney and a judge. You understand patents, and you understand technology better probably than some people in their 20s and 30s, and the emerging technologies that are that most mainstream Americans probably haven't even begun thinking about yet. You're reading and learning and understanding where things are headed, and you understand the implications of all of this, and you understand the national security implications of it. You're so well-rounded with this, and I'm really impressed with it. Can we just talk just a little bit more about why you're so worried about China and that they're catching up and that we may be falling behind?
Well, China has made public several formal planning documents in recent years. One that's gotten a lot of attention is called Made in China 2025. And this plan promises to have China in the leadership on a list of 10 advanced technologies in just 2 more years. And there are other similar documents that the Chinese government has put out. And they don't just put out documents. They've changed their patent system massively every single year for the last 5 years. The very time where in America, we can't get any changes to improve and revive the patent system. So they're not only planning and scheming, but they're acting rapidly to dominate the world economically and militarily, partly through using their patent system as a kind of a weapon of national power and national assertion. And they're really serious about it. They're really good at it. They have enormously skilled people. If you look at their list of technologies they're going to dominate, at least they intend to dominate, and then you look at the list that recent and current administrations have here in America, it's the same list of technologies. They all agree on what these technologies are: AI, quantum computing, biotech, robotics, autonomous vehicles, computer chips, and on and on and on. List of about 20. So both countries are focusing on the exact same technologies, but China's really doing something about it, and we haven't been doing anything constructive about it in a decade. And,
Right.
and for a decade and a half, we've been incrementally destroying the patent system. So we're moving in exactly the opposite direction that we need to be moving. And if you compare our trajectory with China's, I think it's very alarming.
I think it's alarming as well, and I hope that we can wake individual people up around the country who are listening to the podcast and hopefully will watch the documentary we've done and then get involved and help them get involved. They may not be inventors or lawyers or investors, venture capitalists, but all of it, I think it's going to take all of us. It's going to take a grassroots type movement to help the inventors and the lawyers and the venture capitalists who are trying to write things, because the money that we're up against with big tech is overwhelming, and China is also very powerful. So
Yeah, I think you're exactly right. It will take a grassroots movement to change this. Patent geeks like me are not going to be able to win this argument. And it will take a lot of action at the local level. I'm a great believer in local universities, local businesses, helping to educate members of Congress, particularly when they're in their home district. Invite them out to the plant, show them how the patents are being used, show them the benefits of technological advance. They don't need to become patent geeks. They just need to understand the basic economics here, which are not that difficult to understand. But the education has to continue not just in Washington by the work of people like you and your organization or me and groups that I'm affiliated with. It's going to take a lot of action at the state and local level as well. You're exactly right about that. And everybody has to help. Everybody has to help. All business people, all inventors, all technology people, all investment people have to get into this conversation and help to educate the policymakers. You know, they only know what we all tell them.
right.
They aren't magic. They aren't born knowing everything they need to know. So it's a big job, but it can be done. And one of the things I admire so much about what you've done is you've used the medium of movies and podcasts in order to get some of these messages broadly out in the public, which is absolutely necessary. It's not enough to just testify at congressional hearings, as I regularly do, or to write articles. I think I've written 50 articles in the last decade about patents. But, that's a drop in the bucket compared to the efforts of big tech. So it's going to take a whole lot of other people, including at the local level. I like your idea, grassroots movement.
I just think it's that important. One of the, we did the first documentary, Invalidated, and the Innovation Race is our second documentary on this subject. We did this after I did a podcast, just a Facebook Live with Congressman Thomas Massie. And we're talking about several things, including patents and intellectual property. And he talked about how patents are protected in Article 1 of the Constitution. And I just didn't know. I mean, I read the Constitution. I read that was in there, but it was just, honestly, it was just words. It didn't mean a whole lot to me. And he brought it to life. And one of the things he said that struck me was it's in Article 1 of the Constitution. Article 1, not Amendment 1. This is what they agreed on when they wrote the Constitution. This was part of what they agreed on. It isn't the Bill of Rights. It's not things that were added later. That's how important this was. And I've since learned how revolutionary it was to say, okay, you who came up with the idea actually own the idea, and it's your natural right to own it. But what we want to do is to incentivize you to show the world what your idea is. And so we're going to find a way to help do that.
It built the American economy. When the patent statute was first passed in 1790, the U.S. was a very backward, poor, agrarian country. It became the industrial colossus of the planet in the 20th century and helped win 2 world wars that were threatening all civilization. And it amassed prosperity like the world had never seen before. So the patent system from day one of America until recently was the backbone of economic progress. So we went from being this poor, backward country, particularly compared to Britain, to out-inventing Britain. They used to out-invent us in around 1810 or so. And by 1870, we out-invented Britain tenfold because our patent system rewarded the inventor. The British system was very different. The British system was basically the king granting rights to one company to make a certain product. No one else was allowed to make it. And if the owner of that grant of the crown didn't produce, then the patent was voided. So our founders said, no, we don't want to do that. We want to have everybody become an inventor and compete with one another to advance technology in a race, a good race. And we want every American to become an inventor and even to be able to make a living as an inventor. So people like Bell and Westinghouse and the Wright brothers and Eli Whitney and many, many others, they didn't make anything. They were just inventors. It was they were heroes. They were considered saviors of the country, and they were. But now, independent inventors are vilified by some of the big companies and their spokespersons. And as I mentioned, they use all kind of phrases like patent trolls. And one of the things they say is, if you don't make a product, you shouldn't be allowed to have a patent. But that wasn't the idea at all. Going right back to Madison and the founders, the idea was you can make a living inventing if you're good enough at it, or you can make it, or you can do both. But you don't have to do both because we want more invention, not less. That was the basic idea. And they got more invention. They got invention that was at an astonishing pace for 2 centuries. And now we started to unwind that dynamo. The patent system isn't the only thing that drives innovation. It's not the only thing that's important to technological advance, but it's critical. Right. It's one of the critical things. So, okay, you can weaken the patent system, but you're going to pay a big price by doing that. And we're starting to pay the price right now. I think it's insane. I think it's very important to reverse that and get us back into a technological and economic leadership position, and even militarily. I mean, China has supersonic missiles. We don't. Most of the advanced computer chips in the world are made in Asia, not here. Right. So when there's supply chain problems or COVID problems or Ukraine war problems, all of a sudden we can't get all the chips we need. So then auto factories get shut down because they can't get the chips they need for their cars. Okay, so we finally belatedly woke up and said, we better make some of those chips here. So now, just recently, a bill came out of Congress to finance companies to build big factories here, and they're starting to do that. We need a lot more of that kind of revival of manufacturing industries and advanced technologies in America. And one of the key ways to get it is to revive the patent system. It's that simple.
It is that simple. We just have to revive it. Thinking about what you just said, from 1790 to 1870, that's only 80 years. And we went from a brand new country coming out of a war to create the country to being able to out-invent 10 times over the country that we revolted against. That is not a very long time in the span of human history for 80 years for a country to be able to do that. And we're approaching almost 2 decades at this point of weakening our patent system. And I think that if we continue to weaken it, we may not see all of the effects of that weakening in the next 5 or 10 years, but certainly in the next 60 years. And that same amount of time that America leapfrogged over Britain, other countries could leapfrog over us.
It'll probably happen even faster because the pace of change in today's world is so much faster than it was before. If you look at the 20th century, almost every significant invention in the world in the 20th century was invented in America. Almost every single one. If you look at the last 20 years, lots of major breakthrough inventions are being made in other countries, in Europe, in Asia, including China, but not limited to China. So the picture is changing rapidly. We know how to do it right. We did it right for 200 years. We know how to fix it. There are actual vehicles to fix it, penned by Tillis and Coons and Massey and a few others. All we need to do is rally support behind their efforts, pass those bills, and we can reform and revive and strengthen the patent system, and we ought to do it. It's in our own interest. It's desperately needed, probably overdue, but, as they say, better late than never. But we better get going because we don't have endless time.
That's right. Well, I hope that listening to this, it inspires people to take action. And we're going to make sure that we've got ways through Tea Party Patriots Action for them to sign up, to get involved, to take action. And if it isn't on our website right now, we'll make sure that we've got it even on our documentary website. Sign up so you can take action, because it is important to do that. And we can't just talk about the problem. Our goal isn't just to say, hey, here's a problem that's going on in America, but we do want to fix it. And one of the most amazing things about this issue that I learned after we did the first documentary is most Americans, regardless of political ideology, when you present this problem to them, they all almost are just like, yeah, this is a no-brainer. We need to fix it. Why can't we agree this is something we need to fix? And I saw recently that Senator Coons and Senator Tillis did a press conference together saying we're co-sponsoring each other's bills. It doesn't matter who is the chairman of this subcommittee in the next Congress. We have to get this done.
Yep, those two senators and Congressman Massey, who you mentioned before, are the leading lights in the Congress on these issues, and they're working hard to educate their colleagues, but they need help because people in Congress have 6,000 issues they have to worry about, and not to mention getting reelected and raising money and all that. So they're very distracted. They have a short attention span. They're maybe easily manipulated by clever public relations firms who aren't very honest or very candid. So it's a daunting challenge, but it's entirely doable. And I think you've really got the key. A lot of people think this is a Washington problem, and trade associations and other entities that are in Washington and the Congress that sits in Washington, they're going to take care of all this. I don't think it's going to happen that way. It's going to happen if there's action at the regional and state and local and municipal level where Congress people are educated by ordinary citizens who want to see more growth, more job creation, more national security, being able to stand up to China. They don't have to understand anything about patents, really. Everybody knows that growth is important and technology is important. And so they should stress that with their senators and representatives. And if they do that, they'll listen. I used to work. I spent 7 straight years as a Senate staffer in the 80s. And I can guarantee you that when a university official or a company official or a union official calls up a senator or a congressman or wants to come visit or wants to meet them in the district, they always say yes. They're all ears because that's their job. So they're accessible. It's not like you can't get to talk to them.
Right.
They all have town halls by the millions, which is one way. They all have letter operations where they read the mail. And sure, they have staff help, but they read the more important mail personally. And so they're accessible, they're approachable, they're educable, I guess is the better pronunciation. But we citizens have to do it. We have to get in the act, all of us.
Judge, thank you so much for joining us on the Innovation Race podcast. We really appreciate having you here.
Thank you.
I'm Jenny Beth Martin with Tea Party Patriots Action and executive producer of Innovation Race. You can find more information about Innovation Race at innovationracemovie.com. Again, that's innovationracemovie.com.
The Innovation Race podcast is hosted by Jenny Beth Martin and produced by Kevin Mooneyhan, Lori Heiselman, and Andy Peterson. Luke Livingston directs the video podcast. Innovation Race podcast is a production of Tea Party Patriots Action. For more information, visit teapartypatriots.org. That's teapartypatriots.org.